A true leader has the confidence to stand alone, the courage to make tough decisions, and the compassion to listen to the needs of others. We are honored to welcome Honorable Mr. Justice Bhushan Ramkrishna Gavai, Judge Supreme Court of India and Executive Chairman, National Legal Services Authority. His Lordship's fierce dedication to social justice, compassion, and equality is known to all. His Lordship's contributions continue to shape the Indian legal landscape significantly. His Lordship's legal approach is marked by keen understanding of socio-economic realities that impact the people seeking justice. We are privileged by the presence of Your Lordship on this occasion today. With utmost respect, I invite His Lordship to address the gathering.
My esteemed colleague, Honorable Justice Surya Kant, the Chairman of the Supreme Court Legal Services Committee, my esteemed colleagues, Honorable Justice Rajesh Vindal, Honorable Justice Augustine Masih, the Chief Justice of Punjab and Haryana High Court, Honorable Shri Shin Laguji, the Chief Justice of Jammu and Kashmir and Ladakh, Honorable Tashir Abastanji, the Acting Chief Justice of the Himachal Pradesh High Court, Tarlok Singh Chauhanji, Honorable Justice Sandwalia, the Executive Chairman of the Punjab SALSA, Honorable Justice Arun Palli, the Executive Chairman of Haryana SALSA, Honorable Justice Lisa Gill, the Chairman of the Chandigarh SALSA, Honorable Justice Atul Sridharan, the Executive Chairman of Jammu and Kashmir SALSA, and Honorable Justice Sanjeev Kumar, the Executive Chairman of Ladakh SALSA, my all esteemed colleagues, brothers and sisters from Punjab and Haryana High Court, as well as Jammu and Kashmir and Himachal High Court, the Advocate General of State of Punjab, Gurpinder Singh Ji, the other honorable judges from the District Judiciary and Trial Judiciary from the participating states, the members of and the office bearers of District Legal Services Authorities as well as Taluka Legal Services Authorities, my colleagues from NALSA, the members of the Registry of the High Court of Punjab and Haryana, and dear friends. It gives me a great pleasure to be with you all this morning. As my brother and a friend for a long time, Justice Surya Kant, told you that this is my first event where I am participating as the Executive Chairman of the NALSA. As a matter of fact, Justice Surya Kant and I have a long relationship. Both of us became the judges almost at the same time. I became a judge of the Bombay High Court in November 2003 and Justice Surya Kant became a judge of Punjab and Haryana High Court in February 2005, almost 3 months, 2004. And we met for the first time in 2005 when Justice Surya Kant and I had come to Delhi to attend the wedding of the then senior advocate Vinod Bobde, who was from our Nagpur, and Justice Surya Kant had an opportunity to work with him in many important matters. And thereafter, for last almost 2 decades, our bond grew. Incidentally, we came to Delhi and joined the Supreme Court on the same day, and then we have been working together. We worked together with Justice Bobde on the bench for almost 6 months, and therefore when it was coming that I will be chairing NALSA and he will be chairing the Supreme Court Legal Services Committee, he had decided that the first function should be in Chandigarh, and coincidentally, that's how both of us are here today. It's a privilege to stand today to interact with you all at the Regional Conference on Empowering the Marginalized Citizens and a Step Towards Social Justice, Achievements Made and Roadmap Ahead. This theme is both timely and essential, urging us to reflect on the strides we have made in securing rights for the marginalized communities, while also challenging us to lay down a clear and actionable path for the future. Empowering marginalized citizens is not just a matter of legal or economic support. We must remember that the empowerment is achieved when individuals are not only uplifted but also equipped to advocate for themselves and participate in the social life of the nation. Under a constitutional framework, Article 39A places an obligation on the state to ensure that, and I quote, the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizens by reason of economic or other disabilities, unquote. The Legal Services Authorities Act 1987 was enacted to further a constitutional vision. The legal services authorities under the Act have a mandate to provide free legal aid to those in need, particularly to marginalized sections of society, including prisoners. Therefore, when Justice Sandwalia had given us subjects, we had divided the subjects between Justice Surya Kant and myself. I have chosen to speak on the rights of the prisoners. I would like to speak on the role of the legal services authorities in protecting prisoners' rights and care for their children and families. Prisoners in India face a diverse set of challenges. Their plight becomes concerning because 70% of the prisoners are under trials. They have not even been found guilty yet, but still they are languishing in the prisons. And this is many a times due to lack of legal access. From January 2024 to August 2024, legal services were provided to 1,84,749 persons in custody. As enlisted under Section 12G of the Legal Services Authorities Act 1987, this includes 1,035 in Chandigarh, 7,059 in Haryana, 539 in Himachal Pradesh, 971 in Jammu and Kashmir, and 21,093 in the state of Punjab. While these achievements are a positive indication of our commitment, ongoing and increased efforts will be essential to ensure timely and comprehensive legal support reaches every individual in the need in the country. The Supreme Court of India has recognized the rights of prisoners in a series of cases. The court has held that the right to live with dignity extends even to the incarcerated. In Sunil Batra, the court took serious note of the treatment meted out to the undertrials, convicts, and those awaiting the death penalty. Authoring the judgment, Justice BR Gavai emphasized the need to relook at the prison conditions. In Charles Sobraj versus Superintendent of Central Jail, this court upheld the fundamental rights of prisoners against the undue harshness of prison practices. The Supreme Court in Hussain-Ara Khatun also emphasized that there is a duty of the state to ensure free legal aid. In Francis Corral-Emulin, the court struck down a rule which regulated the right of a detainee to have interviews with a legal advisor of his choice as violative of Article 14 and 21. In Shabnam, the court elicited the principle that human dignity should be preserved, and even when a prisoner is sentenced to death. In Muhammad Hussain, it was held that the right of a person charged with crime to have the services of a lawyer is fundamental and essential to a fair trial. And very recently, in the last month itself, the court struck down the provisions of various prison manuals which discriminated against the prisoners on the basis of their caste. The work which was allotted to them was allotted on the basis of their caste, and this was clearly hitting at the very basic promise of equality as enshrined in our constitution. The jurisprudence is a powerful testament to the court's commitment to uphold human rights within the penal system, ensuring that prisoners are not deprived of their basic rights, irrespective of their circumstances. In line with this jurisprudence, the legal services authorities serve as a crucial bridge between incarcerated individuals and the justice system, working to guarantee that even those who are confined retain their fundamental rights. These authorities play an instrumental role in providing free legal aid to the prisoners, ensuring that they have access to fair legal representations and are not left vulnerable to unjust treatment due to lack of resources or knowledge. However, a major hindrance to prisoners accessing their rights is their lack of awareness about the legal protections that are available to them. To address this, raising legal awarenesses within prison is crucial. In consultation with all the stakeholders, NALSA has been working towards strengthening the mechanisms to protect prisoners. I am happy to share that this year so far, legal services institutions have organized around 17,992 legal awareness and overreach programs in jails and observation homes. Out of them, 36 were held in Chandigarh, 1462 in Haryana, 193 in Himachal Pradesh, 95 in Jammu and Kashmir, and 1383 in Punjab. Recognizing the critical need for early intervention, NALSA's guidelines also place a strong emphasis on providing legal aid during the pre-trial stages. These guidelines provide a duty of the police to notify the suspect of his right to have legal assistance during interrogation. This is a crucial phase where timely legal assistance can significantly impact on individuals' access to justice, as it allows the informed decisions and better defense preparations at the very outset. From January 2024 to August 2024, pan-India, 24,173 persons were given legal assistance at the pre-arrest stage and in police stations. 23,079 persons were given legal assistance at the arrest stage, and 2,25,134 persons were given legal assistance at the remand stage. Our output in providing legal assistance at the pre-arrest, arrest, and remand stage remains critically low, with only a handful of states making notable efforts in this regard nationwide. Within this region, while states like Himachal Pradesh and Jammu and Kashmir have made some commendable efforts, there is still a pressing need for greater actions. The other states, Haryana and Punjab and the Union Territory of Chandigarh, need to work more in this area, highlighting urgent and focused efforts. Strengthening legal aid at pre-arrest, arrest and remand stage is essential to ensure that individuals receive timely assistance before formal detention, preventing undue hardship and upholding justice at the very outset. Furthermore, it is imperative that we create a mechanism to monitor and document the status of all inmates in prisons. In this regard, Regulation 3 of the National Legal Services Authority's Regulation 2011 for the first time provided for the establishment of legal services clinics in jails. NALSA's standard operating procedure on access to legal aid services to prisoners and functioning of the prison's legal aid clinics 2022 also provides an effective mechanism to ensure that prisoners' rights are protected. Under this SOP, there are provisions for two types of inspection visits in the prisons. One shall be undertaken by the Secretary of the DLSA and the other is to be done by the chairperson of the DLSA, that is the district and session judge. During these inspections, these authorities need to speak to prisoners about the legal aid provided and check the status report on all inmates made by the visiting lawyers. On my own, I have decided to visit as much as prisons as I can. In fact, I was scheduled to visit the Chandigarh prison yesterday, but since our flight could not take off from Amritsar at the right time, I could not do it. But I will be making an effort because I am told that Chandigarh prison is a model prison and we certainly visiting it. Justice Surya Kant has also talked about the prison in Simla and he said that it's also one of the model prisons. In fact, I will be taking the cooperation of all my learned brothers in the Supreme Court. I will be requesting them to assist the NALSA in reaching the NALSA outreach to all the states, along with my esteemed brother Justice Surya Kant, who would be taking over the NALSA from me. We will work together and request all of our colleagues to be a part of our attempt to provide legal aid to the needy. Under the SOP, the legal aid clinics are run by pre-legal volunteers, also known as Adhikar Mitra. These legal aid clinics serve as a vital lifeline, offering prisoners access to legal resources, guidance and support in navigating their cases. At present, we have around 1,251 prison legal aid clinics and 1,386 prisoners who are deployed as PLVs in jails throughout the country. To maximize the effectiveness of these clinics, it is essential to focus on creating better infrastructure for them. This SOP on a prison legal aid clinic has now received judicial validation in the case of Sukanya Shanta versus Union of India. In the judgment, the court directed that, and I quote, the DLSS and the Board of Visitors formed under the Model Prison Manual 2016 shall jointly conduct regular inspections to identify with the caste-based discrimination or similar discriminatory practices as highlighted in the judgment are still taking place inside prisons, unquote. In the process of strengthening and making legal services more professional, NALSA has also adopted another legal aid delivery-based model, that is Legal Aid Defense Counsel system, for providing legal aid in criminal matters on the lines of public defender system in other countries on pilot basis for a specific period in some districts to see how effective and successful such changes in the approach will be. Legal aid defense counsel systems involve full-time engagement of lawyers with a support system. The legal aid defense counsels, also known as Nyaya Rakshaks, are deployed in all the DLSs across the country with 581 chief LADCs, 949 deputy chief LADCs and 1664 assistant LDSs. Various categories of cases, including bail cases, are assigned to LADCs from January 2024 to August 2024. 65,585 bail cases were assigned to LADCs, out of which 55,976 bail cases have been disposed of. Himachal Pradesh saw a commendable rate of resolution with over 96% of the cases addressed, ensuring timely legal resources for those awaiting trial. Although with Chandigarh there is a need to strengthen the framework of LADCs for prisoners, the other states, Punjab, Haryana and Jammu and Kashmir, have shown a great promise with their results. It is also crucial that when we discuss prisoners' rights, we must also reflect that the prisoners may have been the sole breadwinner of the family, which may now be facing economic hardships. In this regard, a preventive and strategic program was undertaken by the NALSA for the welfare of family members of jail inmates, titled A Campaign for Legal Assistance to the Family Members of the Prisoners. The features of this program included formal interaction with jail inmates and family members, follow-up action on the concerns raised in the said interactions irrespective of the location of the inmate and family, and assistance in availing benefits under the government schemes. The campaign's target group included convicts with remaining imprisonment for 6 months or more, and under trials having continuous detention for more than 1 year. To share a success story from the campaign, in Chhattisgarh, one of the DLSs deputed 2 PLVs to assist a pregnant woman whose husband was in a prison and who was deserted by her in-laws. The PLVs took help from the local government in getting the woman admitted to the government hospital, where she received adequate medical care and delivered a child. Furthermore, in a suo motu public interest litigation in 2023, the Delhi High Court noted that there are already many relevant schemes for the welfare of family members of prisoners, which are currently in operation, but there is a need to increase awareness of such schemes. The High Court assigned a responsibility to NALSA to organize campaigns akin to a campaign for legal assistance to the family members of the prisoners, but with a broadened scope aiming to reach the maximum number of prisoners and under trials and their families. To emphasize again, the responsibilities of legal services authorities extend beyond the immediate needs of the prisoners themselves. They must also consider the well-being of prisoners' families, especially their children. The children of the incarcerated parents are often among the most overlooked victims, facing emotional, social and economic challenges due to the absence of parents. Legal services authorities therefore have a critical role in advocating for and coordinating support system that addresses the unique needs of these families. This involves collaboration with social welfare departments, NGOs, the child welfare committees and other support networks to provide counseling, financial assistance and educational resources for the children affected by parental incarceration. Additionally, legal service authorities can facilitate opportunities for family visits and accommodation and communications, recognizing that maintaining these bonds can be essential for the mental well-being of both the prisoners and their families. For parents behind bars, knowing that their children are cared for can also be a powerful incentive for rehabilitation and eventual reintegration into the society. Furthermore, borrowing from the philosophy of juvenile justice, when we provide love and support to the child in need of care and protection, we prevent them from becoming children in conflict with law. Recently, the Supreme Court has issued a series of directions to enhance the working of legal aid mechanisms. In Suhas Chakma versus Union of India, where I was also a part of the bench, amongst a diverse set of directions, the court held that legal services authorities at different levels shall adopt methods to strengthening the monitoring of prison legal aid clinics and to review their functioning periodically. The Supreme Court also directed that the legal services authorities shall periodically review and update the SOPs of 2022 for the Undertrial Review Committee. The huge gap between total number of persons inflicted by the UTRCs and the number of persons identified by them and recommended for release should be looked into and adequate corrective measures be taken. Similarly, the difference between the number of prisoners, inmates recommended for release and the number of bail applications filed should also be diligently monitored by NALSAs, SALSAs and DLSs, and adequate corrective measures should be taken. On 8th of April 2024, NALSA had released a framework and schedule for a quarterly meeting of UTRCs across all districts of the country in the year 2024. To prevent long period of incarceration during pendency of the trial and to increase awareness among lawyers about the 14 categories of prisoners eligible for review, timely filing of bail applications, recourse to appellate remedy where bail applications are rejected. In a recent judgment, I had held that A long incarceration without trial should not be converted into a punishment without a trial. In the UTRC quarterly meetings held in April and July 2024, over 44,000 prisoners were identified for review, leading to the recommendation of about 29,500 prisoners, which resulted in the release of about 14,700 prisoners. For the UTRC quarterly meeting of October 2024, as per the time frame, consideration of the data is in process and will be released by 29th of November 2024. This year, NALSA also launched a pan-India campaign called Restoring the Youth for identifying juveniles in prisons and rendering legal assistance to them. In recent years, several unfortunate cases have come to light where children have been found languishing in adult prisons without any judicial determination on their plea for juvenility. They remain confined in the dark alleys of adult jails. Recognizing its institutional responsibility, NALSA has instructed all legal services institutions to undertake a campaign to identify such prisoners, more applications for age determination and bail on their behalf, thereby ensuring that they are no longer incarcerated in prisons. So far, 5,184 persons in prisons were prima facie identified as juveniles. 3877 applications were filed by the legal services institutions for age determination of such probable juveniles. 801 such applications remained pending, while 1,451 such applications were allowed and 1,622 applications were dismissed. 782 persons who were determined to be juveniles at the time of commission of the offence were transferred either to child care institutions or place of safety. And 993 such juveniles identified were released on bail. Seeing the result of this initiative, all legal services institutions have been requested to continue with the same and identify probable juveniles in prisons and provide them necessary legal assistance. Our progress thus far sets a foundation, but we must redouble our efforts, especially at this stage, for the benefit of these juveniles. Legal services institutions also play a pivotal role in fostering rehabilitation and reintegration of prisoners in society. In Sundar versus State, the Supreme Court directed NALSA to prepare guidelines on premature release. Consequently, NALSA developed the SOP on the process of preventive release, parole and furlough of prisoners 2022, aimed at providing legal assistance, ensuring operationalization and coordination of efforts to improve the process of premature release, parole and furlough. The premature release of the convicted prisoners is based on the principle of reformation, rehabilitation and reintegration of the prisoners back into the society on the basis of their conduct in prisons. I was happy to note when Justice Surya Kant told me that in the Simla prison, the prisoners not only undertake the manufacture of clothes, but they stitch the white shirts and black pants which are purchased by the lawyers. He also informed me about the prisoners doing a catering service wherein a catering is provided by the prisoners to the outside citizens. I think this steps like this for their reformation will go in a long way. When I was chairman of the Infrastructure Committee of the Bombay High Court, I directed that all furniture in the courts would be purchased only from the prisons. Because we have very good artisans in all the prisons and their furniture is not only good but is also very strong and long lasting. The SALSAs also make effort to implement a range of reformative and rehabilitative programs aimed at enhancing the educational and vocational skills of prisoners. From January 2024 to April 2024, 1,557 prisoners were found eligible for premature release, out of which 892 prisoners were assisted and 440 prisoners were released across the country. It is only with continuous efforts that we can change the scenarios in prisons. I believe that there is a need to strengthen our roots. The legal service authorities at the district and taluka levels need to have robust and effective mechanisms to provide comprehensive legal aid to all those in need. We need to ensure that the regulation and guidelines that are already in effect need to be complied, while also developing new mechanisms to protect the rights of the marginalized. Before I conclude, I would like to thank the Honorable the Chief Justice, the chairmen of the Punjab, Haryana and Chandigarh UT State Legal Services Authorities for giving me an opportunity to be with you this morning, for hosting this wonderful event, for releasing the video clips, because we have seen that the drug abuse, there was a movie Udta Punjab, it's not only a menace in Punjab but is now growing everywhere in the country. The number of NDPS cases are on a high rise. So, preparing the video clips and enlightening the youth about the drug abuse, its disadvantages and the losses it might cause to them would go a long way. I am also happy to inaugurate another video clip which shows about the significant contribution of all the three legal authorities, Punjab, Haryana and Chandigarh. The booklet on victim care and support system would also go a long way in enlightening the victims about the rights available to them. I am sure that all other state legal services authorities would also follow the good steps taken by Punjab, Haryana and Chandigarh legal service authorities. Before I conclude, I would only like to quote what Dr. Ambedkar had said on 25th of November 1949 in the Constituent Assembly. In one of the judgments which I delivered recently, the 7 judges, I begin my judgment with quote, "The matter was so ably argued and opened by your esteemed Advocate General." And I quote Dr. Ambedkar that on 26th of January, we will be entering an era of contradictions. We have assured justice, political, economic and social to our citizens. By ensuring one person, one vote and one value, we have attempted to achieve a political equality. But what about social and economic equality? On an economic plane, we have the entire wealth of the country concentrated in few hands, and the vast majority even finding it difficult to meet 2 ends of just a day. On a social plane, we have a society compartmentalized into 4 compartments, wherein you cannot travel from one compartment to other compartment. And he warned that unless and until we do not make an attempt to eradicate these inequalities, the edifice of democracy which the Constitution has so laboriously built will collapse like a house of cards. And therefore, no doubt that in the last 75 years, the executive, the legislature and the judiciary have marched towards attainment of the social and political justice. I have extensively referred to the Constituent Assembly judgments in that judgment which I delivered, and therefore every step by all of us, by NALSA, by the state legal service authorities, by DLSs, by taluka legal service authorities, should be aimed at achieving the social and economic justice which the framers of our constitution have envisaged. Thank you very much.